Okay, I think that's everybody. Good morning again. As I say, I'm Alison Kirkwood, and with me in the room at a social distance is David Liddle. We're both reporters with the Directorate for Planning and Environmental Appeals, and we have been jointly appointed by Scottish ministers to conduct the examination and thereafter the inquiry, and thereafter to report to them with a recommendation on whether or not the proposal should be approved. I'd like to remind everybody present that this meeting will be recorded and it will be stored as part of the DPA's webcast archive and will be capable of repeated viewing. I have the discretion to terminate or suspend filming if, in my opinion, allowing filming to continue would prejudice the proceedings of the meeting. By participating in this virtual meeting, you are consenting to it being filmed and to the use and storage of the image and sound recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records. Further details can be found in the DPA privacy policy, which is on the DPA section of the Government Scot website. Is everybody okay with that?
Yes.
Thank you.
Yeah.
Yes.
Okay, so so just a reminder in terms of how we will run the meeting. For all those participating, I say keep your video on, but turn your sound to mute except when you are speaking. And for those that are observing, they'll have their video and sound off. Has everybody, if everybody can put their screens on to gallery view, it means that you'll see everybody that's participating in the meeting. There's a button on the left of the screen. If you hover the cursor over it, it should say view, and there's one of the options is gallery. So I'm able to see all of you. If at any time you wish to attract my attention, please wave your hand. It's a small enough meeting that I can see you all, and we'll keep looking out for that. If any parties are in the same room, please note that we'll expect relevant social distancing and other COVID-19 related measures to be observed. I'm not sure whether the participants from the council or from the applicant are together, but it's an important part of keeping us all safe. And if measures aren't being observed, we'll be forced to suspend the meeting. So the purpose of today's meeting is to discuss the procedural arrangements for an examination to consider an application under Section 36 of the Electricity Act 1989 by Scottish Power Renewables for the construction and operation of what would be an extension to Arecleoch wind farm. Just to note, we will not be hearing any views or evidence on the merits of the proposals this morning. Now, you should have all received a copy of the agenda in advance, which sets out the matters to be covered. Has everybody got this?
Yep.
Okay, that's good. Now, we're obviously in strange times. We'll cover the procedural implications of the COVID pandemic later in the agenda. However, as we move through the meeting, our assumption at this point is that we may be able to have in-person oral sessions if we need them, subject to the rules at that time. So that's our sort of assumption as we move forward, but we'll need to have quite a few discussions on the implications of that, and that's one of the purposes of today's meeting. Is everyone content with the agenda and clear about what the purpose of the meeting is? Okay, thank you for your nods. So we'll go on to section 2 of the agenda, which relates to the code of practice for handling inquiries under the Electricity Act. I think it's worthwhile if I outline our approach to public inquiries for Electricity Act applications. Apologies in advance to those who are familiar with them and have heard this before. So there are no statutory rules relating to these procedures. We will deal with the inquiry in accordance with the code of practice for Electricity Act cases, and I provided a link to that document in the agenda. Hopefully you've all had a chance to look through this in advance of today's meeting, but if not, you can do so when you have time. Essentially, this approach allows for flexible procedures. Each topic will be dealt with by the most appropriate mode of examination. Could be an inquiry session, could be a hearing, or could be further written submissions. For some topics, sufficient information will already have been submitted and no further procedures will be required. When we write a report to Scottish Ministers, we'll take into account all the environmental information submitted by the applicant, together with all the consultation responses and letters of representation already lodged. The type of procedure being followed or the absence of any further procedure does not necessarily signify the importance of a particular topic. Our objective is to conduct proceedings in a fair, transparent and efficient manner, and part of the purpose of today's meeting is to seek your views on the procedures to be used. Before we go on to look at the list of topics and our provisional assessment of how each should be heard, which has already been circulated with the agenda, I want to explain briefly the differences between a hearing and inquiry session, just for those of you who aren't familiar with them. Hearing sessions take the form of a structured discussion between the parties involved, which we as reporters would lead. There would be no formal leading of evidence or cross-examination. We would prepare an agenda for each of the hearing sessions in advance after we receive parties' hearing statements. And everyone who has advised us that they want to take part can participate in a particular hearing session. There's no need for legal representation, although parties' lawyers can take part in the discussion. Hearings are generally more informal than inquiry sessions and are particularly suited for topics where there is a difference of opinion on less technical issues. In inquiry sessions, each party is invited to present evidence in turn, and this would be subject to cross-examination by those of an opposing view. Usually parties are legally represented and lawyers will question, cross-examine the witnesses. But it's not essential to have a lawyer. We would also have questions. Inquiry sessions are more formal than hearing sessions and more suited to topics where there's technical evidence. And finally, just to provide some clarifications in terms of topics where further written submission procedures are being used, participants would be asked to submit further information. We may ask you to address particular matters that we would like to further evidence on, and parties would then have the opportunity to comment on the response provided by others. Any questions on the general procedures before we move on to our initial thoughts on the particular topics for this application? Mr. Stevenson. If you're able to unmute your button, you'll be able to speak.
Yeah. You said that in some instances, sufficient evidence has already been supplied. Who takes that decision? Is that the reporter's decision?
It's the reporter's decision based on at the start when the application is transferred to the DPA, we write out to all those who have submitted consultations and representations to the Energy Consents Unit. And based on that, we get an indication as to which parties want to give further evidence and take part in further inquiry. That gives us an indication of which topics may be required to further evidence released on. We also will look through all the documentation that has been submitted. So there may be cases where nobody wishes to submit further representations on a topic, but as reporters we feel we need further information, and we would generally use written submissions to request further information on that. So it's about us having the information, all the information that we need before us to make our recommendation to ministers.
Can we challenge that? Because you did circulate us to ask us if we were satisfied that the pre-hearing should be based on written submissions. And we did say that we weren't happy with that we wanted oral submissions. But now to be told that you've received sufficient evidence on certain aspects of the inquiry and that you will only accept the existing written submissions, can we challenge that?
Part of the purpose of today's meeting is to seek your views on our provisional assessment. So when we move on and we go through each of the topics, if there are topics where we have indicated that we think we don't need any further information, and that's a topic that any of the parties here feel that we do, then yes, that's for you to give us your views on that. So that'll be part of the proceedings today.
Thank you.
Anybody else got any questions generally about the procedures? No. Okay, we'll move on to item 3 on the agenda then. And for these, if you have your appendices in front of you, that would be helpful. So our provisional, we've looked through all the information that's been submitted by the applicant, by consultees, by all the representations that have been submitted, and our provisional assessment of the main issues to be addressed in the report to ministers is summarised in the table set out on Appendix 1. What we've done is group these in the issues covered in the environmental statement. Appendix 2 is a provisional list of the anticipated participants for each inquiry or hearing session. And this is the information that was provided by you in early August when you responded to initial letters when we asked you what sort of information that you were wanting to present further information on and be further involved in the inquiry. So I will be going through getting each of your views individually. But first of all, just more generally, a few questions. In terms of Appendix 1, are there any topics missing from the list? Are there any additional topics that you want to suggest that you think we may have missed? If you could raise your hand if you want to. Yes. Okay. Ms. Crossworth, first of all, please.
SF6 gas, I don't see that anywhere on the topics, and I would like to discuss that further.
Sorry, I didn't. Your audio broke up just at the. I think what topic was it?
SF6 gas.
Okay, we'll consider where that fits in within. Ms. Spence, was there something that was missing from your?
Yes, the dark skies is part of the biosphere, and I think I raised that as briefly in my objection, and I think that is quite a serious consideration, also because we're part of the biosphere.
Okay, thank you. Anybody else? Mr. McGibbon?
Can I just clarify, is the impact on residential amenity, is that included within the visual impact?
Yes, I should have clarified that on the table I have in my notes later on. But yes, the impact on the residential properties we would include under that topic. Anybody else got anything that they want to flag up at this stage in terms of the topics? Okay, if we could move on to Appendix 2 then. I say this is our, oh, sorry, Mr. Andrews. If you unmute your button, I'll be able to hear you.
Yes, thank you.
Okay, yes.
I wanted to bring up the matter of the consequences to this application, as it if there is an approval, say, to the application, the consequences that there's going to be a lot more infrastructure going on, and I think it's one needs to consider the impact of attendant infrastructure to this application, as it's not really as an application about itself, but there's a great deal of consequences on it. And I just wonder if that should not be a matter that is open for discussion.
Okay, I've taken a note of that. So sort of infrastructure implications of the proposal. What we'll do is that we'll take a note of all of these, and we'll consider where they would best fit in. But that's helpful.
Okay, thank you.
Now, Mr. Stevenson.
Yeah, further to the point that I raised at the beginning of the meeting, under Appendix 1, you have access, traffic and transport, and peatland, where you say no further procedure, that you'll rely on material already available. Would it be possible to accept that we require an inquiry session or a hearing session on both of these items?
Okay. At this stage, what I'm just trying to do is check that we've got the topics covered. Then I'll go through each of them and seek your views on the procedure. So we will come to that, Mr. Stevenson. That point, I'm just really trying to clarify that we've covered all the topics, but there'll be plenty of opportunity for you to put forward your views on that. Is that okay? Ms. Spence. Sorry, you've muted yourself on again. Well done.
I was listening to what Chris Andrews was saying, and I have extreme experience of the after effects, particularly when the connection to Kilgallick to the grid was made. We were made to suffer 7 weeks of our road being closed for most of the day, with a 100-mile round trip just to get to the village, that sort of thing. And we think that
sorry, I'll need to stop here in terms of not allowed to sort of consider any evidence through this hearing, but I think what you're saying is that infrastructure is something that you'd be interested in as well.
Well, yes, because these things happen afterwards, and there doesn't seem to be any control of what SPR do, and nobody's keeping an eye on them, in my experience. And I would like to find out how you can control that.
Okay, I've taken a note of that in relation to what Mr. Andrews suggested as well. That's helpful. Okay, if that's the thing, I say we will be seeking views on under each of the topics in terms of the suggested procedure. So we'll come to that. But what just before we do that, what I would like to check is that have we correctly identified the topics on which you wish to give further evidence? So we say we based this on the emails that you sent in. You can change your mind in relation to matters. Once you receive a note of this meeting, you will have 14 days to confirm your participation under each topic. But if there's anything at the minute that you think that we haven't got right, please let us know. Yes, Ms. Crossway.
I just want to clarify about the dark skies and lighting. I've got that topic under lighting, but maybe it should be under a different area.
Okay, well, certainly that would be my assumption at this stage, that it would come under sort of landscape and visual impact, unless there are other impacts in relation to the dark skies that people want to raise. But that's where I would have thought it most naturally would have sit.
Okay, thank you.
Anybody else? Anybody feel that we haven't identified them against the right topics? Okay, Mr. Kelly?
Are you now on to Appendix 2 as opposed to Appendix 1?
Yes, we are. Yes, Appendix 2.
In terms of Appendix 2, for landscape and visual impact, it will be essential that SNH take part in this evidence session. Obviously, I can't go into the evidence, but they did change their mind following a direct intervention by ministers. So it is essential that SNH are there to explain their position.
Okay, I actually have I'd noted that from your representation, and when we get to the discussion on the nature of evidence in relation to the landscape and visual impact, we discussed that. At this stage, what I'm trying to do is just make sure that all the participants within this meeting are attached to the right topics. Okay, I say there is an opportunity for you to decide otherwise whenever you get a note of the meeting, but for now we'll proceed on to the each of the topics. We'll go through each of the topics in Appendix 2 and seek the views of each of you on the intended or the appropriate procedure to follow. What I would ask you to bear in mind is the discussion that we'll need to have under item 4 of the agenda about the implications of the COVID pandemic and how that affects the setting up of inquiry and hearing sessions, and whether it would be possible to cover some of the topics through written submissions. But I say the purpose of today's meeting is to get your views on that. Is that okay? So if we use Appendix 2 as the basis from that, and the first topic that we identified was planning and energy policy, need for the proposal on carbon benefits. It appeared to us that it was logical to group these matters together, and we've identified the likely participants as the applicant, Newlist Community Council, Bardrocket and Knockdolian Estates, and Miss Crossway as the participants. We have suggested that potentially could either be done under further written submissions or a hearing session. So I suppose what I'll be looking for is the views of the parties as to whether or not these matters could be done through written submissions or whether a hearing is required. So if I go to each of these parties in turn, maybe get their views. So Mr. Innes for the applicant.
Yes, perhaps I could start off by making a general point first and then coming to the specifics of the planning and energy policy. It is very clear that in the current circumstances and with the future of formal procedures uncertain, that the procedures that we set out should, I would suggest, try and assist in narrowing issues and ensuring that they're as focused as possible. And against that background, in my submission, there would be a lot of merit in ensuring that the written material may well be available in advance of you taking a final decision as to what formal procedure should actually take place. The reasons I make this suggestion are twofold. First, in relation to further procedure, if that further procedure is to be in person, even with all the applications of social distancing, then the proceedings are tending to take longer, and it is a more complex process in terms of being at the event with documents not being passed to parties and everything else. It's a lot more complicated than a straightforward process that we're all formally used to. That really encourages that if we are to have any oral procedure, that it is very much focused on the critical issues, and that the topics are very well ventilated and properly focused. Furthermore, should the matter be a hearing, and it may well be that a hearing could be conducted in a virtual setting, again, experience suggests that the process is one that potentially takes a little longer, and that's understandable. And equally, for those that are participating, actually participating online often needs breaks, etc. Again, so if there were to be hearing procedures, again, in my submission, that we need to have quite a focus on what the evidence is and what the dispute is in terms of that evidence. And in my submission, therefore, in terms of the various topics, my position would be to encourage an exchange of written submissions to ensure that there's a very clear focus in relation to the matters that are actually potentially in dispute. And certainly I have suggestions in terms of that, whereby it might be helpful that prior to formally fixing further procedure of hearings or public inquiry, that there should be this exchange and potentially a further pre-examination meeting to determine those procedures if necessary. And I just suggest this in light of not just experience of current inquiries, but other proceedings that as a firm we're involved in, is that the process is more difficult in the current circumstances. And it does mean that when we actually go to those processes, it is perhaps even more important that the issues are quite focused rather than a traditional inquiry where perhaps, we do a statement of case, and really it's only by the time we get the preconditions that we get the understanding of what the case is, and etc. So that is a suggestion that I'm putting forward for this. And I might as well say it at the outset that in terms of the applicant's position, we're happy to ensure that we put forward our position first in writing, and then for other parties to be given a chance to respond, and for then possibly to be a pre-examination meeting, further pre-examination meeting to determine whether or not further procedure is required. And this would allow a more focused approach to ensuring that if we are to have oral proceedings, either in person or virtually, that the matters were well focused and ventilated, and that we'd given the matter a real opportunity to narrow issues rather than to have an open process. And that, I mean, as I say, my suggestion is that the applicant should probably go first, because we have resources and we should be capable of getting things rolling. I think in that context, if that were to happen, the trouble with a simultaneous exchange is you then have to go into a simultaneous response to exchange, which tends to exchange matters. I was thinking that the applicant would set out, because we really haven't had a full chance to set out our response to the various representations that have been made on the various topics. We have obviously made our position statement to the consent unit, but that's restricted to 2,000 words. That would then set the applicant's position relative to the position, and then if the council and other parties were given a period to set out their position and potentially respond to what the applicant had said, we'd be in a better position to understand where there were actually differences and what required to be considered. And then I think certainly in terms of timetable, we should timetable now when those further procedures might take place, but we could set a process along the way to make sure that they were really focused procedures. And I appreciate that that puts quite a lot of responsibility on us, but that was sort of a thought process to try and make the proceedings in the current circumstances more effective, efficient, and also still retaining full participation, but clearly trying to bring a focus to matters in the process. So in terms of planning and energy policy and carbon benefits, we were keen to set the current, I mean, obviously it's an ongoing process as policy and legislation develops. We're happy to set out our position relative to that up front and to have set out our written submissions. In terms of timescales, we had a date possibly in October that we'd be capable of delivering those, something like the, let me just get my,
Mr. Innes, it would maybe be helpful before we go into sort of dates, say to get the views of others. I think that's very helpful, and we welcome your thoughts, particularly on the unprecedented times that we're in. And obviously, from the DPA's point of view, we are looking to get that balance between fairness, participation, and efficiency, and ensure that nobody feels that they've been disadvantaged because of the situation that we're in, but that we want to move forward towards us being able to give a recommendation to ministers. So I think that's a very, very helpful. David and I will need to go away after today and think about all the implications doing it. But it's important that that others get an opportunity to respond on that. So in terms of if we just keep it for now, in terms of the planning, energy policy, need and carbon benefits, if we go through the other suggested or likely participants, and that would be Mr. Bukic for the Community Council. What are your thoughts on how that topic could be dealt with?
I don't think I have much comment to make about that, really. I generally would prefer the opportunity for interchange like we're having now, actually, rather than purely written submissions only. I think that's what I would say.
Okay, that's it. Well, the virtual hearings are something that that we have been running, but there is an opportunity to take on board Mr. Innes's advice about making them as focused as possible, so that we're dealing with matters that there's disagreement over, and that we've been able to identify where there's consensus. But that's helpful. Mr. Kelly for the estates.
Thank you, ma'am. A normal face-to-face hearing session on policy, and I would suggest it's combined with socioeconomics rather than having a separate hearing session on socioeconomics.
And how do you feel about virtual hearings? Obviously, I'm aware that you've been attending at Aviemore, so you're probably the person who's got the most up-to-date current experience of how it's working.
It's early days. There are difficulties, perhaps compounded by the issues of bandwidth for broadband in Speyside. I have taken, at the request of the reporters, I spent Friday dipping in and out of the webcasting procedures. I could follow it because I'm involved and I know exactly what's happening. I took soundings from members of the public who were following the webcast, and they found it very, very difficult to follow. In particular, they found it difficult to address the switch between someone speaking and a document appearing on the screen. And it became even more complicated when people were referring to maps, and the resolution was perhaps not as good as it was. So I would say somebody who is really involved and experienced could probably manage on a virtual hearing. For members of the public, it's more challenging. And also, you may have had some feedback 2 or 3 times. the feed went down and we had to take a 10, 15, 20-minute pause during procedures. Having said that, the actual face-to-face sessions where we observed social distancing, I thought went perfectly fine. There was no issues there. But as I say, we've only had 1 week so far.
Okay. Sorry, for others, I should explain there's currently a conjoined wind farm inquiry taking place in Aviemore at the minute that started last week. So they've had 1 week. And obviously we will take lessons learned from that as we move forward. But it's very much a sort of a test case for a real person inquiry sessions on these matters. Okay, Mr. Kelly, I've noted your preference. Finally, Ms. Crossway.
Yes, I would agree with Mr. Ian Kelly over the importance of face-to-face hearing on this. Helen McDade will be my main witness for both planning and energy policy and socioeconomics. So it would be, I agree with Mr. Kelly as well that these two topics should be covered together.
Okay, that's we've got your views on that. I say David and I will need to come together after the meeting and consider how to go forward, and we will communicate with you on that. The next topic is probably the one where we've got most participants, which is the landscape and visual impact. And so that will include cumulative effects, lighting, and the residential visual impact. So a few matters before we seek your views on the procedure. The first one that I've noted was something that Mr. Kelly referred to earlier, with the involvement of Scottish Natural Heritage, or Nature Scot as they are now called. Mr. Kelly indicated that SNH should be required to participate. We've reviewed both their consultation responses and I'm aware that there is useful evidence there, but our feeling is it's very much up to SNH to determine whether or not it will attend the proceedings, and so we don't, while their input would be helpful, we don't view their presence as essential in order for us to reach our view on these matters and then report to ministers. Do you wish to comment, Mr. Kelly?
Thank you, ma'am. It'll end up being a submissions point.
Okay. Second thing that I just wanted to touch on at this stage was in terms of cumulative assessment. Ms. Spence has requested that the proposal be considered together with the other proposed wind farms at Clochry and the Kilgalloch extension. Now, we're aware that these proposals were only at scoping stage when the EIA was undertaken, just because of the time that's passed. We've been appointed to assess this application only, so we've no remit to consider the merits of the other two applications. But perhaps a question to Mr. Innes. Is there intention for the applicant to update the cumulative assessment undertaken as part of the EIA to include Clochry and Kilgalloch extension?
They're both further behind in the process and will again be considered on their own merits, and they would have to take into account clearly this application in terms of their subsequent assessment. And it's essentially at that stage that that cumulative scenario would be assessed for its acceptability, would be at those subsequent proceedings. They are, we're happy to provide an update of what the position is, but I mean, I don't think it really requires. We were required to do an assessment at the time, and it's not really going to help the reporting of this particular application as to considering the cumulative effects with those two projects.
Okay, thanks. Ms. Spence, do you want to comment at all on that? It was a matter that you'd raised.
Yes, the reason I raised it is because the effect of Kilgalleach being added, which was done on the same assessment as Arecleoch and Mark Hill, when no wind farm was actually operative. They, at that point, were saying that because they're 5 kilometres apart, they didn't need to do it. And no wind farm was actually working when they put in the Kilgalleach application. And so they've been doing this for quite a time. And they're trying to say that despite the fact that they have exceeded the noise that they're allowed to make quite frequently, and to my detriment, I have to add, but that putting turbines twice as big nearer is somehow not going to exceed these noise levels. And I cannot see, and I don't think anybody else can, apart from Scottish Power, how that could be possible.
Okay.
I think it's essential that, you know, these things are calculated and considered. They need to know what they're inflicting on us. And they have a perfectly good idea, I'm quite sure, because all these things are done as a desk topic, which I will come to later in my evidence.
Okay, thanks for that. I would say we'll be required to make a decision based on the information that's before us. So it'll be for the applicant to decide what additional information they want to provide in relation to those other farms that have sort of progressed in terms of proposals, and you'll be able to as well within the either within landscape and visual impact or in relation to noise. Okay. In terms of landscape and visual impact, we have suggested in Appendix 1 that this is a matter that we would perhaps have an inquiry procedure for, with potentially up to 8 participants seeking to give further evidence on this topic. Obviously covers quite a range of technical matters in terms of the visual landscape impacts, cumulative aviation lighting, and the residential visual amenity. Obviously, Mr. McInnes, will come to you first. I mean, on your views on that, obviously within the context of what you've said previously. Any particular comments in relation to this particular topic and how that would work from the applicant's point of view?
Yeah, well, again, we're very keen to, sorry, I've fallen over. We're very keen to, we're very keen to, again, make sure that the topic's properly set out and there's a proper basis in where the disputes lie. We've very carefully considered both SNH and Nature Scott and the council submissions and others, and we'd be keen to set out our position in a written statement up front. Equally, I think it's important to recognise that actually the differences between ourselves and the council on this issue are limited and relatively easily identified. I would be keen to do that. To some extent, there's 2 real issues always with landscape and visual. What are the significant effects? And thereafter, the issue about acceptability and its context and etc. Now, obviously, we need to understand the extent to which other parties want to dispute the findings of the environmental report as it relates to landscape and visual in the assessment. And then there is this secondary aspect, which is always one which is there as well, as considering the acceptability of the effects that are found. And I think it's important, therefore, that there's a clear understanding as to the extent to which there's a dispute in terms of that first element. The second element on acceptability is largely a matter of judgment, and we can all make our views known and the witnesses can make their views known, but it is more a question of that judgment. But I think it's essential that we have a proper ventilated position as to the extent whether there is disagreement as to the findings of that initial assessment. And that's why we'd be very keen for there to be an exchange on that basis, so that the parties can be very clear as to what the position is. And then the session, whether it be, if it needs to be heard, would be much more focused and would be one which would I would suggest be more manageable. Equally, largely speaking, if there is not such a substantive dispute on the findings of the environmental statement, and it is predominantly a judgment of acceptability, that largely ends up being a matter for the reporters having regard to all that evidence. And whilst it may be interesting to hear lots of people's views about acceptability, that's ultimately a matter for you to recommend to the Scottish ministers based on that information. So it's, again, I think, very important with those range of topics to understand the extent and nature of disagreement, as opposed to just saying we'll have a session where we can all discuss the various issues regarding landscape and visual, because there's a series of steps involved, and we'd be very keen to see these narrowed insofar as we can to test to what extent there is disagreement, and whether it's an disagreement as to assessment, or whether it's a disagreement as to acceptability.
That's helpful. Right, I'm going to let each of the parties that have in relation to landscape and visual impact give an indication as to what their thoughts are on that. Say what we may end doing is the decision on the procedure, but then what we'll need to consider is the scope of that procedure and what matters would need to be covered at it. Mr. McGibbon, for the council, can I maybe come to you first?
Yep, yeah, thanks. I would say the council position essentially set out in our report, which was sent to to the ECU, and essentially we would be keen for written submissions to be the way forward for the council on this topic.
Okay, thank you. Mr. Bucook for the Community Council.
I mean, as before, I would like the opportunity to have an interchange as we're having now. Obviously, one would submit as and when necessary. One would submit written material. I'm happy to do that, but I think one does need the opportunity to have an interchange on that.
Okay, thank you. Mr. Kelly for the estates.
Thank you again. We would be content with a hearing session on this topic. In terms of the cumulative position, as you may know, we're also in the lead into the Glenshero Section 36 inquiry in November, and in that case, the applicant has provided a fully up-to-date cumulative landscape and visual impact assessment. There was also updated information provided for the Moray conjoined inquiries. So a hearing session, but I think it would be helpful if it was informed by an up-to-date cumulative landscape and visual impact assessment.
Okay, thank you. It's turn. Ms. Ellis, you'd like to indicate your thoughts on the procedure for this?
Yes, I would agree with Mr. Bukoki that I'm happy to provide a written evidence, but think that some form of discussion, such as we're having now, either a hearing or an inquiry, would be desirable as well.
Okay, that's helpful. Thank you. Ms. Crosswaite.
I'm happy for and not to actually discuss the visual. I'm happy for Ms. Ellis to do it on my behalf, as we've been discussing this. But I would like to present a witness on the lighting and the effects on the dark sky park, and So I have 2 witnesses that I'm in communication with at the moment that I'm waiting to be confirmed, and so I would prefer to confirm those to you as soon as I've got the confirmation on that.
That's fine. You'll be able to do that in response to the meeting note. There'll be a period of time where we'll need you to confirm, but that'll still be a few weeks away.
Okay, thank you.
Mr. Andrews.
Yes, thank you. I can see it's quite tricky, particularly with documents, to share documents, and but I would like some kind of public or personal meeting. So I think I'll go along with Susan Crosswaite and others on a kind of mixed.
Okay.
Thank you. Right.
That's it. And sorry, Mr. Stevenson.
Yeah, I think it's necessary that we have an inquiry in this, a real inquiry, not a virtual one. I can't see, if we're talking about dates potentially in December, that we may be in the same difficult position regarding COVID as we are now. Hopefully we won't be. And I can't see, if there are a limited number of people who wish to give evidence, that it would be terribly difficult in any case to socially distance and to follow all the necessary procedures under the terms of the pandemic. So I hope that we can have a real inquiry.
Okay, that's helpful to get all your views. So what we will need to discuss later in the agenda is the implications of the in person, and as a group discuss the challenges of that and the implications of that. But we'll come to this. I think at the minute it's important that we understand your thinking on your evidence on this matter, and how you'd like it to be heard. Right, I think there's, I mean, certainly it is a matter that as reporters there are issues that we already, have indicated that we may need further evidence on, and we would provide a list of that to the applicant, and then people would get the opportunity to comment on that. Some of the things that have come up in our considerations is evidence from the applicant in terms of turbine rotation speed and visual effects, what the current position is regarding aviation lighting mitigation that's been referred to by the applicant, a response to the comment made by SNH in their letter about the omission of a nighttime assessment from the Merrick wildland area, given that one's been included for Clockery wind farm proposal. So there are matters coming up in our thinking already, that are perhaps some gaps in the information that we need, and we'll need to consider how best we get that. Mr. Ennis, do you want to comment on any of those specifics?
I think I think I probably better come back appropriately rather than just, and it takes a bit of time. What I would say is, I think the important thing about the process is one of you getting the best information to be able to write the report to the ministers. And I think one of the things about that process is that it is information that's critical to you, and as you've identified already, it's that can come in many formats. And what I've heard is a desire to have certain hearings or public inquiries, but not really why we should have that process. And for example, where there may be a significant dispute as to methodologies, etc., often they can need to be explored or whatever. I just don't. I'm not hearing the why. I'm hearing a desire to have a process, but not necessarily a why. And I think that's why I think it is important that parties set out their positions on these matters, and then we can see the level and nature of dispute, rather than, as I say, the position of it would be desirable to have some sort of process. The process should be the information and understanding the extent to which there's a dispute arising from that. And that, as I say, is very important, because we need to understand, is there a dispute about the findings of the environmental report or not? And I think one of the points about this is that, as Mr. Gribben on behalf of the council identified, their committee report is quite specific as to where it disagrees with the findings of the environmental statement. And from that, actually, from the applicant's position and the council's position, we're at a position where we can identify where the differences lie, and we can identify to you where those differences lie and where our professional differences lie. I think that's really what we and that's why he's fairly confident that his position will be understood before you, because it's set out. And I think equally it is very important that the positions of the parties are set out in a way that sets out the dispute, because that then helps us down the line as to what we're actually needing to resolve and how that should be resolved, whilst fully accepting there's a desire for elements of participation in all these processes.
Okay, that's the thing. Right, I'm going to move on from landscape and visual impact. What I suggest perhaps we do is that we go through each of these topics, and then we'll take a short break. I'm aware that we're already an hour in, and we've still got quite a lot on the agenda. Is that okay with everybody if we press on for a bit longer now, and then we'll take a short comfort break? Okay. Next topic on in the appendices is ecology. Now, we've only noted the applicant and Mr. Stevenson. Maybe come to Mr. Stevenson first. We understand that you wish to give it further evidence in relation to impact on bats. Do you have a view on whether this could be done through written submissions, or whether or not it requires a hearing session?
Yes, I think this could be done by written submission. But just in relation to what Mr. Innes was saying, if we start laying out why we wish to raise some of these issues, either a hearing, an inquiry, or in written submissions, then we're going to have to discuss evidence today, which you specifically said we weren't to do. So I'm not clear about exactly what Mr. Innes is asking us to do today.
Okay, I think certainly from our point of view, it's important that we understand what your thoughts are on it. I don't think we need to go into the details as to why you think that. Part of this process is for your participation and for us to understand whether or not you feel that an oral procedure is required. But I can understand where Mr. Innes is coming from in terms of drilling down to a focused approach. So in terms of ecology, if that's something that can be done from written submissions, that's very helpful to us, and it narrows the focus on the topics where there does need to be other forms of procedure. Next topic is hydrology, including private water supply. Now, we've identified this as a potential inquiry matter, given the technical nature of the evidence that some of the participants have referred to and to wanting to lead. Potentially 3 participants here, obviously the applicant, Ms. Crosswaith and Mr. Stevenson. I'll maybe come to Ms. Crosswaith first, then, in terms of how you feel that.
Yes, I feel that we definitely need an inquiry on this, and my main witness on private water supplies on this will be Dr. Rachel Connor, who has a lot of experience in this particular matter. The councils are responsible for not allowing any deterioration of groundwater, which supplies private water supplies, and this site is on a body of water which serves multiple sites. There are actually 35 private water supplies that could possibly be affected on this site, and also you have the body of water is also draining into the River Stincher eventually, and the Rivers Cree, both.
Okay, so if I can just stop you before we sort of get on to the details of evidence. Have you any indication from Dr. Connor as to how much evidence should be looking to lead? What we're trying to get an idea is in terms of if there was an inquiry session, how long it would need to be.
Well, I've submitted quite a lot of evidence in my objection. I mean, I've been listening to Mr. Innes saying about the statement. I'm sorry, I can't remember the term for it. The statement that Scottish Power make in regard to their position statement. Sorry, I've been listening to what he said about their position statement, and they've only actually reacted in their position statement to what the council, to the objections of the council. I don't know whether they've even bothered to look at the other objections very much. They certainly haven't done anything in the position statement. So there's quite a lot of evidence identified in my objection, which relates to various cases that Dr. Rachel Connor has covered.
Okay, thank you. The other part of this, Mr. Stevenson.
I will defer to Dr. Connor on this. I will pass on my input to her.
Right, well, that's helpful. I mean, generally, I think where there are matters, it is helpful if parties can come together in terms of the presenting of their evidence. So that's a helpful suggestion, Mr. Stevenson. Mr. Innes, you want to give us could you give us your thoughts on this matter in terms of proceedings?
Yes. Again, we're keen to set out our position in full, and we're happy to do that in advance. And in response, we would expect the same from Dr. Connor. I would say, having done quite a lot of previous work on this, that if the case against, or the case that's being presented, is a generic one based on adverse effects of wind farms and private water supplies, that will not get us much further in this particular case. And I think that's why I think it's very important that in the context of the run-up to the processes here, that again, that there is a very clear statement made of exactly what the case is to ensure exactly what the dispute is. And that has to be made in the context of this particular proposal and its relationship. And certainly having been involved in previous inquiries on these matters, it is very site specific in terms of it. And again, clear and prior notice. So again, coming back to that broad theme, I'm happy to say where we got to as the applicant in terms of this particular topic area, and then potentially for Ms. Grothwaite to come back and set out their position. And then we have a clear line of what's actually the issue here. And I think particularly with something like private water supplies and hydrology, that it is very technical, but equally we need to be prior notice of exactly what the position is and which private water supplies are at issue and what the particular concern is. Because otherwise it's a generic point which will not probably assist in the report to ministers, because it is a site-specific issue, and therefore we'll need the data and everything else that's relative to the site. So again, this is another one where clear prior notice of case is absolutely critical, and equally it ensures that the proceedings are focused if to the extent that it's needed. Okay,
that's helpful. So we've taken the notes of that, and we'll get back to you all on our thoughts on that one. Next one is noise, including infrasound and low frequency noise. we've noted down the applicant, Miss Spence and Miss Crosswaite. Again, we've identified, because of the technical nature of the evidence that we've that have been sort of put before us already, we've indicated potentially that we may need an inquiry for this. Then I'll maybe come to the parties first before going back to Mr. Innes. Ms. Spence, have you thoughts on proceedings in terms of the evidence that you want to put in front of us?
Yes, I think that at least the inquiry should take place as a proper inquiry, and I think, if possible, not just relating to noise, but to the other subjects too, that this is a public inquiry, and the public who are going to be affected are mainly in the Bar Hill area and Colmanel, and therefore possibly the public should have great access to the inquiry, because obviously it is going to affect them a lot if it goes ahead. And I would suggest that maybe Bar Hill Hall would be big enough for the public inquiry, given that there aren't great numbers, and there might be accommodation for press to be involved, and also for the public.
Okay, we do need to have quite a detailed discussion on suggested venues for inquiry, and we'll come to that later in the agenda, and certainly the input from local residents on suggestions. But we have to caveat that with the rules and the precautions that we need to take because of the COVID pandemic. So if you could hold that thought and that suggestion, we'll get to it later in the agenda. In terms of if there was an inquiry, what length of evidence do you envisage that you would be leading on it?
Well, I can usually be fairly succinct, and I would say half an hour to 40 minutes.
Okay, that's helpful. Ms. Crosswaite, you've obviously raised issues in relation to noise as well.
Yes, thank you. Yes, I would like to nominate Dr. John Yelland with Melvin Grosvenor, who will act as lay advocate. Melvin Grosvenor is in the meeting with us, and also Professor Mariana Alves Pereira. She lives in Portugal and would prefer to give evidence by Zoom link or some such thing because of for obvious reasons. There's a number of things that we're not happy with. We're unhappy with the noise impact assessments. After visiting many of the sites, we consider many of the locations are non-compliant, and we would request site visits with the which we would want to attend, which I know you've got in the agenda. We do not consider that the proxy properties are a fair representation of the...
Ms. Crosswaite, can I maybe just stop you there, because we're getting into sort of some of your evidence, which we need to avoid today.
Yeah, well, I thought Mr. Innes just wanted some of the reasons why we wanted an inquiry, and I have a whole list of them.
We need to keep that for another day.
Okay, that's fine.
Okay. But yeah, so I know you've got potentially three witnesses, so that it may take some time for us to go through that.
We would think at least one day, if not more.
Okay, that's helpful to give your indication on that. Mr. Innes, anything further on this particular topic that's different from what you've said on the others? Because I can see there's a common theme to the applicants' views.
The issue is that this is an inquiry into objections to the proposal. Certainly some of the topic matters that appear to be raised by Mrs. Crosswaite seem to go beyond the representations that are already made. And equally, having reviewed those submissions in some detail, it certainly seems that some of the representations are effectively directed at ministers and directed at ETSU. And I think there are issues here about the extent of evidence that would be relevant. And therefore, again, I think it's quite important that a full case is set out and that there is a further debate potentially about the extent of the evidence in relation to matters of noise. They should be restricted to considering the application. And this is not the forum in which to debate the merits of wider government policy in relation to the application of ETSU and other related matters. I think there are restrictions on the extent and scope of noise evidence that would be relevant. And I am concerned that those may go further. And this is not the time to debate that particular aspect, but what it lends itself to is ensuring that there is a proper and adequate ventilation of what the case is, and that there may need to be further discussion about the extent of that case and how it relates to the representations that have been submitted to the application.
Okay, that's helpful, and that's something that David and I will discuss. Ms. Spence, you want to come back on that, and then I'll come to you, Mr. Grosvenor.
Yes, there have been some further developments since we were allowed to put in our objections, and I would like to be sure that I can enlighten you all about those, because they do have a particular bearing on the case. And whilst Mr. Ennis clearly wants to restrict the evidence available on this for reasons that it might obstruct their plans, I feel that it is far better that you are aware of all this information at the planning stage, so that this can be turned down, frankly.
Okay, well, say all parties obviously got their views on the...
Yeah, the other thing is that I will be using a witness, Dr. Angela Armstrong, who is a retired GP, and a statement from my neighbours who simply want to supply a written statement connected with what I'm going to say. And that is Laura Brown, who is my next door neighbour.
Okay, that's useful. I think what I can certainly pick up from what Mr. Rennes is saying, which is a reminder to everybody that the purpose of the examination is to look at this particular proposal, and therefore it's bringing the relevance of your evidence to the application before us, rather than sort of generic changes to policy. I think that's my understanding of that. In terms of the evidence that you want to bring, I mean, we will be in further communication with you on each of the topics, and the witnesses that you wanted to bring, and we'll move that forward. But say the purpose of the inquiry is to enable you to give the evidence in relation to this particular proposal, so you won't be prevented from doing that.
Thank you.
Okay.
Can I just comment?
Sorry, Mr. Grosvenor. Sorry. Yes, of course you can.
Just to pick up on Mr. Innes' point, there is an inference that we're looking at government policy. The main evidence, or part of the evidence that will be presented, is that ETSU, yes, it's part of it, but it's also very specific to the way ETSU is being applied when assessing the noise impact assessment. So there mustn't be a watering down or a cover-up or distinction saying, well, we can't discuss ETSU because it's government policy. But the issues we have is that how the ETSU regulations have been applied in assessing the locations, which is quite specific.
Okay, thank you. Right, I'll move on from noise, if that's okay. Now, we already touched on the next topic is the socio-economics, including tourism. There's been a suggestion that this should be grouped with the first topic in terms of the planning and energy policy need and carbon benefits. Parties that had raised this as an issue were Mr. Andrews, Ms. Crosswaite and Mr. Kelly. So we're seeking views as to whether or not this could be addressed through further written submissions or a hearing. We put that out there. If I go through each of the parties, obviously, if it was a hearing, it would be for us to group it with other topics if this considered to be helpful. Mr. Andrews, have you got a view on your evidence in relation to this matter as to whether it could be dealt with through written submissions or whether a hearing would be required?
Yes, I mean, I would prefer that it does go to further a hearing because the application is very much about the locality and the place, and there are unique characteristics of this application and also, of course, the locality here is also unique, and it is terribly important, I think, for everyone's clarity and understanding to bring those two matters into juxtaposition. And so I think it is a very relevant particularity, and I'm glad that you distinguished it in your provisional assessment here. But I would defer to other contributors, of course. But I would like this to be, it's of incredibly relevant to the outcome of this application. Okay, thank you. Ms. Crosswaite?
Yes, as I said earlier, Helen McDade is my witness for this. She's a very experienced witness. She has worked with Mr. Kelly on a number of cases, I think, as well. And so I think she would be happy with a hearing.
Okay, thank you. Mr. Kelly, is there any more? You obviously suggested that a hearing alongside the other topics. Anything further you want to add?
No, nothing, ma'am. I will approach this in terms of SPP, paragraph 169, net economic impact. So I remain of the view a hearing and possibly best combined with the policy hearing.
Okay, that's helpful. Okay, the next one on my list that I want to is that conditions and planning obligations. So it's necessary for us to consider what conditions and possibly planning obligations would be required if consent is granted. This is routine for all wind farm inquiries. We need to provide a set of suggested conditions to minister whether or not we recommend approval or refusal. So the discussion of it doesn't mean anything in terms of the outcome. It's suggested that this matter could be dealt with through written submissions with the potential for a hearing if necessary, if the matters aren't agreed. Now, this is likely to involve the applicant and the council in the first instance, but anyone who wishes to comment on draft conditions or matters to be covered would be given the opportunity to do so. Sorry, Mr. Grosvenor, if you want to.
Yeah, we would certainly want to comment on the noise conditions and be involved in that discussion as we have been on previous occasions. Okay.
I suppose what our suggestion would be that the council and the applicant get together in the first instance and come up with a set of draft conditions and suggested matters if they need to be covered in planning obligations, and then other parties being given the opportunity to comment on that. Would ask the council and the applicant to make sure that they cover all the matters that have been raised by statutory consultees. We noticed that there's a number of the responses that came from consultees suggested conditions if the application is to be approved. So we'd need all these to be addressed, and if they're not to be included in conditions, then an explanation as to why not. Can maybe come to the council first. Is that as a suggested way forward? Is that something that the council would be?
Completely reasonable to the council. Yeah.
From the applicant's point of view, does that sound a good starting point?
Yeah, we're very keen to kick that off with the council and to see how far we can get. I think there's every possibility that we'll get a pretty advanced set of conditions. We've got a pro forma that we can work with from consents unit, and obviously build upon the particularities of the application and the consultee responses, and hopefully we could do it in a manner where we build up a set of conditions with a table and comments, etc. So hopefully we will get a table from where the council and the applicant are, and if we've got any disagreements, those disagreements documented and why, and then obviously other parties can join in and to that process in terms of commenting on conditions. And absolutely delighted to kick that off and try and get that progressed.
Yeah, that's so say all parties. Sorry, Ms. Crossworth, you want to come back on that?
Yes, I would just like to come back on private water supplies on that, about mitigation and conditions, and extending to more than just the closest properties as well. Thank you. Okay, I say as a way of moving this matter forward in a way that all parties get a chance to comment, and so you've got something to respond on rather than or to respond to rather than just raising issues. Does that sound okay, Ms. Spence?
Yes, I, in my objection, suggested that because the effect of the already existing 184 turbines that surround my property are good, have altered my quality of life so considerably that should this, bearing in mind that it's to be followed by Chermarie, Strannoch and goodness knows what in addition to these, should this be consented, the possibility of them turning off all 184 plus turbines is obviously not going to happen. I suggested that, that they should consider very seriously the fact that they would need to buy me out because it would be impossible to live in my property and I would have to abandon it with no funds to buy another property. And I think that that should be a condition of them getting planning consent for this. I also think that there should be some guaranteed way of ensuring that when the conditions are put on the planning consent, that they should have some means and that the council should be given funds because they are very short of money to actually ensure that the conditions are carried out.
Okay, I think we're stretching into sort of some matters of evidence, but certainly we'll go through your.
I couldn't explain it without enlightening you about it.
Yeah. Okay. That's useful. So we'll set out those procedures in our meeting note, and that's something that we should be able to hopefully the applicant and the council can kick off on relatively quickly. Now, in terms of other topics, I know obviously Mr. Stevenson, I know wants to come in on access, traffic and transport, but what I was just going to do was run through the other topics which we consider that no further procedure is needed. And that's not that they're not important, but that, that we've got the material in front of us already from the representations and the consultation responses that we don't feel that we need necessarily have further evidence on. I'll just list these and then I'll come to Mr. Stevenson, and then if there's any other topics that people feel that that should be on the list for further procedure, then you can let me know. So we have ornithology, cultural heritage and archaeology, access, traffic and transport, which we'll come to, forestry, peatland, public rights-of-way core paths, shadow flicker, and aviation and broadcasting. So those are topics that we don't feel that we necessarily need further submissions on in order to prepare our report. So I'll come to you first, Mr. Stevenson. Do you want to add to the comments that you made earlier about the transport matters?
Yeah, on the transport matters, we are looking at, you know, a huge amount of rock material being transported into the site if the application goes ahead. We're talking about over 122,000 cubic tons of rock in 18-ton lorry loads over a period of 18 months. I think that needs further discussion at a hearing, or indeed at a public inquiry. I think written submissions is not sufficient to aerate that for the public's, from the public's viewpoint.
Okay. Right, that's. And in the interest of time, are there any other of those topics that people feel that we've missed? Yes, Mr. Stevenson.
Peatland, I also, sorry, yeah, I think on the mission, simply to say that, you know, no further procedure is necessary on this. I think we do need to give some oxygen to this at a public inquiry or at a hearing, but preferably a public inquiry.
Is this a matter that you want to give evidence on?
It is indeed, yeah.
Yeah. Okay. That's right. The other things that I need just want to go back to at the start. There were a couple of other issues that people felt weren't on the list. So one was the infrastructure, which Mr. Andrews and Ms. Spence raised. Is that something that could be addressed through written submissions, or is it something that needs an oral session? This was the kind of the knock-on implications of the proposal. And the other one was the SF6 gas, which Ms. Crosswaite raised. If we could consider, if you could give me your views on how you feel that those would need to be dealt with. Mr. Andrews, do you want to go first? Sorry, I'll take Mr. Andrews first in terms of the infrastructure. Your thoughts on that?
Yes. Well, again, this is a small village that is going to be impacted quite severely by not only this application, but other applications that are queuing up behind it. It is of significant importance that the industrialization of the landscape is taken notice of. And I think generally about this application, there seems to be a lack of a kind of overview of the whole application. And I think it's very important, if I could ask, that that the inquiry does have some kind of opening discussion, statements from participants, because as I have said previously, this is a unique application in many ways, and the consequences for this village and this locality are really, really important. I'm not sure if this could only be written.
Yeah, could this be dealt with in amongst the landscape and visual assessment, or is it raising different issues from your point of view?
Well, it does cross over into other things, I suppose, and I can understand why you should want to put them into another category. Again, I would defer to other participants here as to their judgment, but it still is of some, I think, vital concern.
Okay.
I would like it to be distinguished in some way, but it could be a category of another section.
Yeah. Okay. We'll give some thought to that, Ms. Spence.
Thank you.
Well, the previous wind farms that have been constructed have impacted on the life of the village to a very considerable extent. Damage has been done to people's property and not addressed and not repaired. For instance,
okay, I'm going to have to stop you because we're getting on to the kind
right,
of,
okay,
there will be an opportunity for you to give these
yes,
views, but it's just really your thoughts on what's the best way of presenting
I
those
think
views.
it should be a category of impact on the public life in the village. There were quite a number of incidents in the last simple just connection to the grid, okay, that were really causing great inconvenience to a large number of people, relatively speaking. I know we're a small community.
We'll give some thoughts as to where that could slot in, so it doesn't get lost in the consideration of issues. Mr. Grosvenor, you want to come in?
Yeah, I mean, in previous inquiries I've been involved with in England, many inquiries in England, we've always had a public session where local residents could air their views and give their statements. I don't see any provision in this inquiry for that. Is that going to happen or not?
It's not something that we've given time for at this stage, and particularly I think given the consideration that of the COVID pandemic in terms of how we run oral sessions, it makes it much more difficult. The purpose of the letter that went out to all those who had submitted representations on the application was to ask them, did they want to be further involved? And the implication of the not was, it was saying you were relying on your existing written submissions. So so people are participating in terms of their comments are already there, but it isn't envisaged that they would take part in further sessions of the inquiry, other than the people that are on the screen at the moment.
But this goes to the heart of whether there should be an inquiry where people can actually come along. I know we've got the issue of the pandemic, but I mean, Ms. Spence has suggested hearings at the village hall. Surely, given the size of this particular application, we are in unprecedented territory. I mean, we're talking about the first turbines at 200 metres to blade tip, very close to a rural community that's got a significant number of turbines already. Maybe people haven't fully understood what the implications are. And of course, the visual and landscape session, in my view, should be in an inquiry session where people can actually look at the maps and, you know, participate on that and see the evidence if they so wish.
Okay, well that's your thoughts on that are helpful. Obviously, we need to consider how best to proceed within the basis of the code of practice that that we referred to you, and that gives you gives you the opportunity to look at the guidance that we are making these decisions on. I suggest that we take a short break before we move on to item 4 on the agenda. A lot of what the discussion that we've had so far is going to influence where we're going. We need to set out where the Scottish Government, where the DPA are at in terms of holding real life inquiries and hearing sessions and explain the implications of those. So I suggest we have a short break and make it 12:10. So is 10 minutes long enough? Okay, if we come back at 12:20, would that be okay? Okay, thank you.
Oh.
Check the list. No. Okay, I think we're just missing Mr. Bucook from the... Yep, excellent. Okay, welcome back, everybody. A few things just in the interlude. David and I have been having a quick chat, and certainly in terms of the matters that have been raised, I think there's some parts of the agenda it's not going to be possible for us to cover today because of the both the suggestions by Mr. Innes and the other matters that have been raised. So I think we need to go away and think about how best to proceed. The other point is that I need to finish the meeting at 1 o'clock because the technology is needed to be setting up for another meeting. But there are another number of points on the agenda that would be really useful to get your views on, I think. And then what we will do is that we'll set up possibly another pre-examination meeting to follow up on some of the matters that need further discussion. Is that okay with everybody? Okay, in terms of item 4 of the agenda, what it would be helpful to understand is, as we go forward in terms of making the decision as to whether or not we can have in-person inquiry hearing sessions or virtual, it's whether anybody's got any particular issues in terms of concerns about attending in-person sessions or concerns about us holding them virtually. It would be useful to hear anybody's views. If you just want to wave your hand, if you've got any thoughts on kind of the principles of how we do that. Mr. McGibbon.
Thanks. I'd just like to say the council would be very keen for virtual meetings if it's going to be a hearing. Certainly that's the way the council's been operating. We've not been holding kind of face-to-face public meetings, so we'd be strongly positioned to say we'd rather have virtual if a hearing was required.
Okay, thank you. Anybody else? Ms. Crosswaite? Yeah, Ms. Crosswaite.
Yes, well, I have actually the opposite views, that I feel that some of this, particularly noise, water and visual landscape, needs to be done in face-to-face, because I think Mr. Kelly made the a suggestion that is very difficult for people who are not used to these kind of virtual inquiries to follow detail and detailed maps and detailed visuals, and there'll be lots of detail in the noise that unless you're really experienced technically, it's very difficult to do it virtually. And I think that actually There are actually a small number of us here, and the hall is very large, and if we're sensible and take all the precautions, and socially distance, it's very easy to do these things. And I'm very much
we'll come on to potential venues in a wee minute, but it's say that point's been made, so it'll be useful if people have got different points to make. It be useful to hear them. Mr. Innes. Yeah, Mr. Innes.
Yes, in terms of where we are, clearly matters are very uncertain, and whilst proceedings have commenced up in Aviemore in relation to a public inquiry, which can join public inquiry in a very large facility, and it appears to be sort of functioning. My concern is effectively one where there is every likelihood is that there may be issues both with the timing of any formal hearing in person, but also for individuals potentially down to participate. Insofar as any hearing physically that took place, clearly some organisations that we would be working with would have employees. They would have to do their own risk assessment. And I can tell you at the moment, a lot of those organisations are taking the view that unless it's absolutely essential, no in-person meeting should take place. So I cannot at this stage say that 100% that we would get to a position whereby that a physical hearing could take place. And what I would say that if a plan is progressed to help conduct a physical hearing or inquiry, that there also has to be a backup in relation to potentially doing the matter by alternative means, should that not prove possible. I say that because there are important timing issues. I mean, this application has been in the system some time, and equally there are events next year around access to markets which hadn't been available to onshore wind for considerable periods of time. So there are issues that my clients have in terms of timing. That's not in any way trying to truncate the process of trying to consider this application properly, but it does mean that it would be very difficult if there's significant delays down the line for a decision to potentially be taken in time for those matters next year. And there are obviously duties incumbent on, in terms of Climate Change Act, about facilitating developments that help meet targets. So time's an issue, and what I'm concerned about is that if we do set down an opportunity to do physical appearances, then I think we should also have a substitute. Equally, I think we should try to make sure that those physical hearings are restricted to absolutely what is necessary. And I think that puts a premium on making sure, as I've probably a slightly broken record, about making sure that we have a clear indication of what the dispute is and what we're there to resolve essentially at any formal in-present hearings or inquiry. So that's my general position, not against, but I think there are likely to be significant challenges, and equally I would encourage there to be consideration of a fallback should it not prove to be possible to hold such an event.
It's helpful. What it may be useful to come in before we hear from others, and I'll give everybody an opportunity to speak in this. In terms of a venue, we have been looking into potential options, and I think what is clear is that the nature and the size of venues that we would need to use for in-person sessions are very different from what they were previously before the pandemic. So in the past, it sounds like the suggestion, I don't know the natures of the hall, but we have used village halls, and our starting point is always to hold in-person sessions as close to the application site and the communities that are affected, and you know, we start there and work out. However, in terms of the procedural arrangements and the risk assessments that has gone on for the inquiry in Aviemore that's been referred to, are throwing up huge challenges, and in terms of finding locations that are close by, it's pretty impossible. So the things that we need to look at are the Aviemore inquiry is in a venue that can hold 1,000 people, and the hotel, McDonald's hotels, have put a limit on attendees in a room at one time as 30. 30 people in a room of 1,000 is a very big ask for anything within the vicinity of the site. So I think I think we have to be realistic in terms of that to have a in-person inquiry is not going to be able to take place next to Bar Hill for this appeal. We're starting to look at whether there's any facilities there. We haven't looked at in details. I know there's a hotel in Stranraer, but you're really talking about a big sort of wedding type venue with other smaller rooms. I think one of the other requirements is that there are rooms, other breakout rooms, so that people can have discussions without having to get into huddles in groups to keep the the parties safe. Also about it being a venue where people can travel to easily, so they're not all, so people don't have to all get into their individual cars and travel safely. So I say that the logistics of holding inquiries has certainly introduced a lot of different factors. I understand that I think there's a case in yes, David, was it Argyll and Bute? Was the there's an inquiry being raised for a case in Argyll and Bute, and they've had to go to Glasgow. So I suppose it's just putting that out there, particularly for the local residents, as to what that would mean for your participation in in-person inquiry or hearing sessions, and what difficulties that would bring for you, and how you envisaged, taking part in this inquiry. Anybody want to come in on that? Yes, Mr. Kelly.
I think it's fair to say that the procedures that have evolved at Aviemore for the in-person inquiry and hearing sessions have worked. It's taken a little bit of effort by everyone, but they have worked. The feeling was that the room we could have possibly got by with a smaller room. We're all kind of lost in that big room. But creating an electronic library of documents that everybody had on a USB stick, displaying the documents electronically in the room, and making sure everybody had a hard copy of the visualizations has enabled the procedures to work. The sole downside is the exclusion of the public, and they are basically excluded, which is, I think, quite a serious issue. For the Mori inquiries, the fallback position was to postpone until there was a date where a face-to-face inquiry could be held, and then the further fallback was a virtual. So there was a three stage there. There was hold the inquiry. If that's not possible, go to a fallback date, and if that's not possible, then consider a virtual inquiry, but only as a last resort. So I would very strongly favour trying to hold a face-to-face inquiry, taking on board the experience at Aviemore.
Okay, thanks, Mr. Kelly. Ms. Crosswaite.
I would suggest the possibility of Northwest Castle Hotel in Stranraer. That is a big wedding venue that would possibly work and would be easy for, I would have thought, most of the people who live locally, or alternatively Ayr. None of these places is a problem for myself to get to, but I don't know about other people.
Okay, that's useful. Thanks for the suggestions. Mr. Stevenson?
In the 90s, when the Northern Ireland Interconnector had a public inquiry, it was held in one of the colleges in Ayr. So there are many venues in Ayr or the Northwest Castle, as Susan Crosswaite suggested in Stranraer, where you could accommodate a face-to-face inquiry. So I entirely agree with Mr. Kelly I think a face-to-face inquiry is the first priority that we should be aiming for. The fallback position as a very last resort would have to be a virtual hearing. I mean, we didn't ask for the pandemic, and we shouldn't use the pandemic as a way of trying to duck the necessity of public involvement in this, where we are looking at an application that could destroy people's lives in a tiny village community. So we must not look at the time problem as an issue. If we can hold a public inquiry, even if that means delaying the whole thing, then a public inquiry, I think, is essential.
Okay, thanks for that. Ms. Spence?
If it should prove impossible to hold sessions as a public inquiry, surely a setup could be arranged, say in Bar Hill Hall, where the public could perhaps have somebody directing it, have a big screen up, and they could get either access to the meetings as they happen virtually, or they could get an update as to what is happening and be asked to submit any comments that they may have and extra topics that they might want to have raised at that point, so that they get some input into it.
Yeah, I think that, I mean, certainly the inquiry sessions would be webcast, and people would be able to view them live. I think what we need to always to make sure is that if you're bringing people together to view things, that they're done in a safe way. I mean, all these questions and considerations are about keeping everybody that's involved in the inquiry safe, and it's not about finding, ways to avoid public sessions. I think the Abbey Moor has faced a lot of challenges. I think but it's been very helpful from us that that's gone before us. But I mean, generally the public aren't able to attend, these sessions. The public accessibility is provided through the webcasting, which isn't the way that things have been done in the past. We are definitely in different parameters, and say the availability of sharing documents and having things out that are very easy for the public to view and to pick up is something that's not able to be done in the current situations. The other challenge we have, I suppose, is that we're making a decision about something that's potentially going to happen in a few months' time. I take the points that Mr. Innes says, is that where places are going in and out of sort of, local lockdowns is something that we're just going to have to factor in, that we don't know where, where we're going to be. We can make plans, we can make contingencies, and we can take all your views into account, but it's not an ideal situation. We're not able to do what we would normally do and what everybody feels comfortable about doing, because it feels like the right thing to do. So we're definitely feeling our way, and we will get the feedback from the Abbey Moor inquiries. I think they've got another 2 weeks to go, so we'll be able to learn from them what works and what doesn't. The other thing is the venue that we choose really needs to have its own corporate risk assessment. So again, the responsibility to put on a local hall to keep everybody safe would be very difficult for the key holder, who would normally be able to make those facilities available. Now somebody had their hand up, Mr. Bukoke.
Yeah, I just if the public can't attend these things in person, then to my mind, there are fewer arguments for a face-to-face meeting, and the risks, current risks of doing so, grow therefore in proportion. Listening to what's been said, I don't think I would really support the idea of a face-to-face meeting, really.
Okay, that's yeah, it's the reality of it all. Whenever you start to drill down to how it all works, it's challenging. Ms. Crosswaite.
One venue that might be considered would be Ayr Racecourse. I've been at a number of events there and helped actually organise events there. So that's a huge possibility. And I think considering what Mr. Bukoch says, and everyone has to take responsibility for how they feel that they can move forward. And I think that there should be an opportunity for a face-to-face inquiry for those who feel that it is the best thing to do, but also the possibility for an input via video feed or Zoom for those who aren't comfortable with face-to-face. As I said, one of my witnesses is Dr. Mariana Alves Pierres, and she lives in Portugal, and she very much would prefer to give her evidence by some kind of internet feed.
Okay, I think that is something I think that's happening in Aviemore this week. That that some of the witnesses are giving evidence. So again, we'll get useful feedback in terms of how that works. So certainly the principle of that is something that could be done. And if there are in-person sessions and some people don't feel comfortable attending, then we'll certainly be exploring that. So in terms of next steps and venue, I mean, we will go away after all this, regardless of what we said, and look into detailed options, and those are helpful suggestions, and certainly we will keep it as local as we can. So if we can have something in Stranraer or Ayr that met the criteria in terms of safety, then that would certainly be our preference as well. But we'll do that. Ms. Spence, you looking to come in?
Yes. During the preliminary meeting and the deposit of the plans in the hall of Bar Hill, the hall was closed so often, and people made special journeys. I know that Harriet did to see these documents. The hall was either locked up without notice, the documents were locked up in a cupboard, and nobody was available to unlock it and make them available. And so the people in Bar Hill have had very, very small opportunity, unless they have comprehensive access to the things online, to actually know precisely what is involved. And despite that, out of 160 households that were consulted, 86% objected to this proposal. And I think very strongly that whatever the method of the inquiry, that these people should have the opportunity to know what is going on as it goes on. So whatever is decided about whether we have a venue for a people-to-people inquiry or whether it is a virtual inquiry, they have a right to know what is being said as it goes on, and possibly it could be made available in the hall for people to go as and when they're able to, because don't forget there are still people who actually have to go out to work and they're not available.
Okay, no, I think you make some very, very valid points, and we will take those away and think how we can ensure that that local people know about these, and I think this is a learning curve that we're all on in terms of how we move these forward within the current climate, and we certainly are keen to do the best we can on that basis. Okay, I'm conscious of the time. What I did want to, we had initially, before sort of the start of discussions, considered timescales, just so we could get some input from yourselves in terms of availability, or more important, non-availability for potential dates for sessions, either in person or virtually. Now, as a starting point, we asked in the agenda if participants could confirm their availability in the couple of weeks before Christmas. So what would be helpful is to know, is there anybody that's not available on those dates? And also then just sort of, are there any dates either the few weeks before that or into January, which are definite no-goes? If I sort of go around from the applicant, first of all, is there?
I've only checked the dates you provided, and we would be able to work within those. I suspect within the timing of this hearing, we've got a quarter of an hour left. I just wonder whether that people could come back in writing, because it's clear we're going to need a second pre-examination meeting. Yeah. And in terms of just making a positive suggestion to keep things moving, my suggestion is that the applicant should, and this is something you can take away, to produce something in writing by the 9th of October on the various topics that you are going to take forward. The applicant would put forward, insofar as they have a position on all those topics, their position by that date. And that, say, by a date on, say, a couple of weeks or 3 weeks, the end of October, all other parties put in their position on those matters. Through that would then mean we have a focus to what we might then be able to achieve in terms of what's in dispute. Equally, within that time scale, I think a draft set of core conditions should probably be circulated core documents by the 9th of October, again, for other parties to comment on. And similarly, I would suggest that the draft conditions could possibly be circulated by the end of 30th of October as well, because obviously that would take slightly longer because it's between two parties, the council and ourselves, but we would be keen to try and kick that off and at least start off with having something before you by that sort of time scale. That would seem to then allow perhaps a meeting thereafter to then determine what procedures were required the following month and the timescales for lodging everything. And we would suggest that effectively these written submissions could either be a statement of case or a hearing statement, depending on how you viewed it. And that would leave, should there need to be formal evidence, only the requirement for preconditions to be lodged further, or if there were responses or refinements of matters, that could be probably accommodated within that schedule. But it seems to me that that offers maximum flexibility, maximum prior disclosure, and we'd be in a better position to understand the full extent of the dispute between the parties, and we can then, probably by that stage, take a clearer view as to what might be possible in December in terms of, are we still in the current circumstances? Have actually circumstances which I think on all predictions, winter could be even more challenging than we currently are insofar as matters, and we may have different guidance that's applicable in terms of holding events at that time, which would push us towards one way or another. But at least it might allow between that time to work out a venue, to have a fallback, and then the next pre-exam meeting could be, focused on what we were actually going to do and anything further. But I put that forward, and obviously you can take it away. But those were sort of dates that sort of fitted a realistic timescale for I think parties taking matters forward in terms of not being unduly close to this meeting. And I think it is not unrealistic to expect the applicant to be capable of producing stuff by the timescale I've set out in October. And 3 weeks is not just a response. It would, obviously, other parties would be preparing what they need to prepare in advance, and they would have 3 weeks to potentially respond to anything that had been raised by the applicant. So I just set that as a starter to try and essentially help matters forward.
That's certainly there are definite merits in terms of what you're saying. Certainly the time scales are similar. If we were talking about starting on the 7th of December, those are the time scales that parties would be needing to be preparing their information. So I think it's for David and I to have a chat based on the views today, and to see how we can move this forward in a way that allows everybody to have the views with the constraints that we're currently working on, and we'll do that by getting back to you in our note of the meeting. So, say anybody else have any non-availability in the period sort of December, January, because we'll take a note of all of that. Mr. Kelly?
I'm free in the dates you suggested in December. I wouldn't like to see any oral evidence procedure in advance of that, because in November I have the Glen Sherrill Section 36 wind farm inquiry, looking at a week and a half in the middle of November for that. But the December dates you have suggested are fine. Thank you.
And what about into January?
No issues with January, as far as I'm aware. No, none.
Okay, that's helpful for us to know. Now, somebody else had their hand up. I'll go Mr. Buckhook first of all.
Yeah, just the December dates are a little bit tight and unknown for me. Generally prefer sort of more towards mid-January, really.
Okay, is it that you're not available, or you just think
well,
that
I have really will likely be travelling elsewhere.
Okay, that's fine. That's all you need to listen.
But I don't know whether that's going to happen or not. But I mean,
okay,
the likelihood. So.
Okay, Mr. McGibbon.
Thanks. Obviously, one of our main concerns is landscape visual, and we used a consultant to get that opinion. She's actually unavailable at those dates in December, but she's available in January. We'd also like to add, we've got quite big time and workload pressures at the moment in the team, so to get kind of draft conditions up by the end of October would be pressing us, to be honest with you.
Okay. It is obviously challenging to sort of, everybody else has got, there's lots of other things on, but we need to move this forward in an efficient way, and so we'll do the best we can to accommodate everybody, but certainly, I mean, I say, in terms of the guidance notes that the DPA work under, timescales are tight, and I sympathise with the council, and I know particularly in the circumstances where people aren't in the office, it makes it more difficult to move things forward. But we'll just try and press it on as best we can, taking account of the views. Anybody else got anything they want to add in terms of dates, Mr. Stevenson?
Yeah. I'm available in the December or January dates. At this point, that may change from time to time. I would put in a plea that all documents from the applicant are circulated to everyone who has taken part in today's hearing, in order that we can respond in the way Mr. Innes has asked us to.
Okay, I think sort of the normal practice is that the documents will be sent to parties, and they'll all be available on the DPA website, so people would have access to them from that. Okay, so in terms next steps, I had put on in item 7 of the agenda was kind of dates for all exchange of documents. I don't think it's appropriate for us to go through those in any detail. We'll do that at the further PM. In terms of site inspections, David and I have already made an initial visit to the site and the area, and on an unaccompanied basis, and the general practice at the minute, given current situation, is for us to do unaccompanied site inspections unless it's not possible. So we will make further site inspections during proceedings, and either in the lead up to sessions or after sessions. So I suppose what we would perhaps be looking for, any comments for yourselves in terms of locations that you feel that we should visit to make sure that we don't miss those. But that could be done in writing to us. If there are locations where we need access to private property, what our practice has been on other caseloads is to seek permission to access those on an unaccompanied basis. So that's something that perhaps the residential properties that are mentioned in the visual impact assessment, things like that. But if you could give some thought to, I say, places that we should visit, we'll take those on board. Does anybody feel that there's anywhere we need to go to on an accompanied basis? Yes, Ms. Cosworth.
Some of the places where the noise impact assessments have been taken, maybe I think myself and I think Melvin Grosvenor and Dr. John Yelland would possibly want to be there to suggest what we would have considered more practical and you know, to reflect the amenity of the properties.
I mean, it wouldn't be normal that during a site inspection we're not allowed to hear evidence. It's really about pointing things out that perhaps you've referred to. So, I mean, it might be that you can give us a written note of what you would want us to look at. The difficulty with accompanied inspections is that representatives need to come from both sides, so it starts to become quite a big group. And again, in the interest of keeping everybody safe, it's difficult to manage that. So, unless it's unavoidable, our approach would be to have these accompanied, albeit with your input on a written basis.
Right. Could I just ask Melvin Grosvenor to perhaps comment on that?
Mr. Grosvenor, if you have any thoughts?
Yeah, I mean, we can provide you with details, but sometimes it's difficult to sort of lay that out unless you're actually on the site itself. So there wouldn't necessarily need to be 3 people. One of us could probably come. We could travel independently of you as long as we made sure that we were there at the same time.
We'll come back. We'll come back to that. It might be that you can visit separately, get your notes, but that's the context that we're working in. To say, but we will go and see.
We understand that. We understand that, but with noise, it's quite specific. So you know, it's not a question of turning up and thinking, well, is this relevant or isn't that relevant? We need to sort of make quite clear our, you know,
okay,
the assessments that we
take that away. Mr. Andrews, you want to come in?
Yes, briefly. A location would be the High Street in Bar Hill, where the turbines, well, would be visually seen. And I could probably, well...
yeah, certainly the High Street in Bar Hill is included, I think, as one of the viewpoints in the visual landscape and visual assessment. So I think that one goes without saying. We'll probably be there on a number of occasions. Okay, well, I say what we'll do is we'll give you the opportunity to make suggestions in writing of places that we need to go. I'm just conscious of the time. Ms. Spence, is there something you want to?
Yes, there is some opinion that no one should be able to see more than one wind farm at a time. On a place in my property, you can actually see 3, 4 wind farms. When Jummery is constructed, that'll be 5. If this goes ahead, the Arecleoch one, they will certainly be able to see the large turbines. How many more am I expected to look at? Not
In terms of the site inspection, you know, if we are able to come to your property and look at it from there, if that would be something that would be part of your evidence.
I think it would open your eyes considerably.
Okay, that's fine. That's fine. That's helpful. Okay, just on the last few matters, to number 9, in terms of contact with the DPA, hopefully you've all, Jane Robertson is the case officer, and all contact should be through her in the first instance. She'll pass on anything to David and I that we need to. Now, again, most of the case officers are mostly working from home at the minute, so if you email her as contact rather than trying to phone. And you can also keep in touch with any developments on the case via the DPA website. The case reference is WIN-370-2. So as any documents come in, they get uploaded and are available for everybody. All those that are interested and aren't part of these proceedings can still keep track of what's happening. Next stage in terms of what we will do is we will issue a note of this meeting setting out where we've got to. I think, as perhaps we expected, you know, there's still a lot of unknowns, but you've given really helpful input in terms of moving this forward. But I think we will likely will need to have a further pre-examination meeting. On receiving the note, what we're asking to do is to confirm the nature of your position once we're able to set out what procedures. So again, that might not be after this meeting, it might be after the further one. So I think that covers everything that we need to discuss today. Is there anything on a procedural point of view or any questions anybody has before we finish off?
Just one plea in terms of the note of this meeting and the sort of interim procedural decisions you take. Obviously, I've made certain commitments that we would try and meet timescales, and that seems quite important down the line. The more notice we have, the easier that will be to achieve. But I appreciate that it may take a bit of time for you to consider what happened today. But if we could get some notice of what's required, because obviously that would be helpful. But appreciate that you know, we are keen to progress matters, and certainly that would be helpful.
Yeah, no, certainly. I mean, we aim to get the note out as quickly as possible. We've probably got a few more discussions to have than normal, but we'll try to give you all as much notice as possible, because so you're aware that you've if there are deadlines, you've got other things going on as well. So we'll do our best for that. Anything else from anybody at this stage? No. Well, thank you all very much for your participation and for your assistance today. And I'll probably see you all again. But thanks very much. So I now formally close the meeting, and we'll take it from there. Okay, thank you.
Bye-bye.